Good morning. We have many panelists who have come in and traveled far to present to our committee. And so I wish to get on with the matter of business, and we will be fairly strict on time. I'll try and give you a warning ahead of time, 3 minutes, 2 minutes, 1 minute, cut. So just sometimes have a look at me. I'll try and signal how much time you have. I'd like to start first by indicating that we are on the unceded territory of the Algonquin people. Pursuant to Standing Order 108-2, the motion adopted on Wednesday, October 26, 2016, the committee resumes its study on the subject matter of Bill S-3, an act to amend the Indian Act, elimination of sex-based inequities in registration. Our first panel will include representatives from the Assembly of First Nations of Quebec and Labrador, the Assembly of First Nations, I have it duplicated, Vivian, Michael, and Cynthia Smith, but I have the wrong, Quebec Native Women's, and Lynn Gell. So I would invite the first panel to please come up and take your positions. And I believe, do we have the chief online on teleconference? Chief, are you there?
Yes, good morning.
Good morning.
Okay.
Very good. We have 10 minutes for each presentation. Some groups have one presenter, other groups have two presenters. It's up to you how to divide your time. In front of us we have Mr. Norton, and perhaps you could lead off and tell us how you would like to proceed.
Thank you very much. Chief Picard and I agreed that we would divide up some of the time. He'll lead off by giving a statement on behalf of the AFNQL, and from there I will finish the presentation. Mine will be a little more than 10 minutes because we've agreed that he would be brief.
All right. So we're going to start with you, Chief. You want to get going, and I won't cut into your time anymore. Please, go ahead.
Yeah, thank you. Thank you very much, Madam Chair and members of the committee. And certainly want to acknowledge the fact that the proceedings are being held on traditional Algonquin territory, unceded territory. I also want to pay greetings to the other panelists this morning, and my greetings to Grand Chief Norton of Kahnawake, the Mohawk Nation. You heard earlier this week from Chief Rick Obamsawin from the Abenaki Nation and the community of Odanak, who presented his views on behalf of his community, and understanding that the case at hand, the Deshano case, is originating from his community. And what you'll hear this morning is another point of view, from another community within our region, and we understand that it's a very delicate matter, a matter that certainly is of concern to a majority of our nations. And it's been a concern for quite some time. I would have to say, and I guess the sad part in all of this, and this is certainly the case in terms of the identification, membership, and whatever you want to call it in the communities, is many times, oftentimes, the government is directed by the courts. It's very sad that it has come to that, and I guess it puts in perspective the fact that many times, too many times, we seem to be cornered in a situation where there's a failure in the political process, which often leads us to courts as the last recourse. And as I said earlier, this is a very sensitive issue. And speaking on behalf of our region, we try to facilitate meetings to deal with this in light of the court decision, but understanding that as a regional entity or body, we try to provide all the time and space needed for communities to express their point of views, and then convey whenever possible a position to the government, and which is what we did following a consultation that was held in Montreal as of September 2016, and we followed up with a letter to the Prime Minister in October of last year, and the letter really states clearly, where we stand as a region, in always trying to reflect and respect the positions of the different communities. The last thing I'll say before I pass it over to Grand Chief Norton is ultimately, in spite of the different point of views, ultimately I think we can all agree, and this is a position that we support, that ultimately we, our communities and their leadership are the only ones that can exercise the authority of determining their membership. And this is something in a position that is supported by all. And we will present to the committee a written statement before the end of the day tomorrow that will add to the comments I just provided this morning. And again, my apologies for not being there in person, but I feel that it is important for Grand Chief Norton as well to present there in person on behalf of his community and nation. So thank you very much, Madam Chair.
Thank you. Thank you, Ghislain. Madam Chairman, you should have by now a copy of a letter that we forwarded to you. It should have come in yesterday, and it outlines our situation, our position, and our very sincere dissatisfaction with the way things have progressed. In any event, we take the position, and the reason why I'm here today is just to clarify and to make sure there's an understanding that regardless of whatever happens here, whatever happens in courts, no one will decide for us what we are going to do. That reconfirms the last time we were here when my fellow chief and I, Gus Nahawaii, made a presentation, and that's what we spoke of. It is the community's intentions and decisions to do what they have to do. There are people at home who I can tell you right now, if they were here, would say, we don't care what you do. Do whatever you want. We know what we have to do, and we're doing it as we speak, and that's what's happening now. It's worthwhile mentioning and recalling and remembering that, we Kahnawake have always had a situation where we've dealt with this matter very sincerely, and there have been points in time in history where there's actually been some physical movement in order to send a message to anybody and everybody about our circumstances. And I am not promoting that now. What I'm talking about simply is that we've embarked on a process, and our process is going this way. The federal government's process is going the other way. Now, whether those two will ever come together again, I don't know. But there's not much we can say or see or do to pull you back in line, and we'll have to continue on our route. There's no question about it. And we do this because we're concerned about the future of our children, the future of our nation, the future of our languages and cultures. You have here in Ottawa a federal list that has on or about 5,000 names on there that do not meet the criteria that we have established in our community. Many of those people on that list know nothing about us, probably don't care about us, and the only thing they care about is the benefits that they will reap once they are recognized, once they can come into Ganawage and exercise their rights. As it is right now, those people, just because they have a band card, can actually go and purchase land. They don't even have to ask us. All they do is through INAC. Go to the Department of Indian Affairs. As long as they have a willing seller in Ganawage, they can do that. So I wanted to use that as an example about how we have at this point in time, we have, in certain sectors, we do not have control, but in other areas we do. Public pressure, and that's what our intention is. We are facing court battles. We are facing constitutional challenge or charter challenges because of the stance that we've taken. But we are committed, and most of those challenges come from within, not without. There are people within our community who say, you're not doing right. Your law is illegal. What you're doing is illegal. Yet on the other hand, we continue to do what we have to do. So court cases may be won against us, but what will they gain? Some dollars? Will they gain the recognition that they can come back into the community, reside amongst us, flaunt our law in our face, tell us that, you have no authority. The authority is here in Ottawa and at the federal government under the Indian Act, and things of that nature. And that's what we resent. That's what we're against. That's what what drives us even more than ever before. We're structuring ourselves with programs, cultural activities, all the very things that are necessary for us to be able to survive culturally, and in the modern day world too at the same time. So that's about all I can say at this point, given the shortness of the opportunity. But you do have a letter in front of you. I believe you have it. You should have it. That basically states, it outlines our position. That's fresh off the press. Yauko.
Thank you very much. I think you've expressed your position very well. Next, we can move to Lynn Gell to give our final panelists a chance to settle down. And please, I don't want to take your time. Go ahead, Lynn.
Kwe makanak dodan pikwakin gan indinjaba Peterborough Megwan dida gizigate manado kwe indigenous cause and dashaganashi knows when Lynn Gale. Hi, thank you for inviting me here today. Welcome to Algonquin Anishinaabe territory. This is my home territory, and so I'm happy to be here. I've been working on the issue of sex discrimination in the Indian Act for more than 32 years. It was in 1945 when my great-grandmother, Annie Maness, was informed by Indian agent H.P. Ruddy that she became a white woman when she married Joseph Gagne, who was only Indian through his mother, Angeline Jocko. That was 72 years ago, yet the sex discrimination that denied my great-grandmother continues to deny my nieces and nephews today. When the Indian Act was amended in '85 to bring it in line with the Charter of Rights, the very provisions that protected children of unknown and unstated paternity were suspiciously removed from the Indian Act, and it became silent on the matter. Subsequently, INAC then began their process of discriminating against these children at the departmental level through a proof of paternity policy that assumed all unknown and unstated paternity situations were non-Indian men. In their process of harming Indigenous mothers and children through this policy, INAC claimed they lacked the ability of reason and moral judgment. In INAC's defense, the Department of Justice also argued Indigenous women would take advantage of Indian status registration rights if there was a gap in the policy. It took me 22 years to move through Canada's court system. In this process, I was against many barriers, such as a mother who didn't want me to look critically at issues of paternity, a lack of funds to move the process through the court system in a good way, INAC's deep pockets of money gained through unilateral access to Indigenous land and resources, and INAC's absolute failure to disclose evidence so it could be properly adjudicated as per the rule of law. Regardless of the misery imposed, this past April, the Ontario Court of Appeal judgment came through and it was determined I won. In short, the court determined that INAC's proof of paternity policy that assumed all unknown and unstated paternity situations were non-Indian was unreasonable. The process of defending against my quest for Indian status cost Canada more than $750,000. Yet I was told I was the mischievous one. It is now clear to me that Canada is hell-bent on eliminating status Indians and the associated treaty rights through the methods of sex discrimination and off the backs of Indigenous women and their descendants. While lawyers view the outcome of my court case as a victory, I struggle with this joy. I'm happy that the court struck down INAC's proof of paternity policy, and I'm happy that the clauses that my legal representatives, Emily LaHaye and Mary Eberts, put forward, and the evolution of the clauses established through consultation with Minister Bennett's office. One of the clauses directs INAC to accept circumstantial evidence, and the other one directs INAC to not to assume non-Indian paternity in situations of rape. That said, I'm not happy that the judges said I was only entitled to 6-2 status. This is wrong. I was born pre-1985, and therefore I should be entitled to 6-1A status. My great-grandmother's brother's descendants are all entitled to be registered under 6-1A. With this so-called court remedy of granting me 6-2 status, I am only entitled to being less than because of my matrilineal ancestry. Indigenous women have worked hard to resolve the sex discrimination. Mary Tuax Early, Jeanette Corbier-Laval, Yvonne Bedard, Sandra Lovelace, Sharon MacGyver. Together, this government moves forward. If this government moves forward with the 6-1A all-the-way remedy, as I hope, a remedy that addresses all the sex discrimination in the Indian Act, Prime Minister Justin Trudeau and Minister Carolyn Bennett and the rest of Canada will truly have something to celebrate. Otherwise, Canada will remain stained. Again, it took me 22 years to move through Canada's court system where, in the end, the so-called remedy offered is nothing but a new form of sex discrimination. A new form of sex discrimination. This is not fair and is out of line with the Charter, and Canada can do better than this. So the first thing I really want to clarify is the discussion of the need to respect the nation-to-nation consultations. They will never occur if the matrilineal descendants are missing from First Nation bands. Never. So right there, that's not happening. And so while INAC claims they cannot move forward with the 6-1A all-the-way remedy and thus remove all the sex discrimination because of the claim need to consult on a nation-to-nation basis, at the same time, INAC prevents First Nations from welcoming their members through imposed fiscal restraints that are not rooted in genuinely valuing what is nation-to-nation, such as sharing the land and resources in an equal way and in a way that Indigenous nations are able to embrace matrilineal descendants. On the one hand, Canada is saying it cannot resolve all the sex discrimination as it must respect the nation-to-nation relationship. Yet on the other hand, it doesn't really want the Indigenous nations to enter into what are genuine nation-to-nation discussions. The second thing that I'd really like to add clarity to that is that, yes, it is true that First Nations, such as my grandmother's band, conflate Indian status and band membership. This practice is being argued by INAC as their excuse not to resolve all the sex discrimination, as there's the need for First Nations to be consulted. We need to keep in mind that First Nation band memberships are within the jurisdiction of the First Nations, not INAC. And that said, regardless, the goal here that we're discussing today is the need to resolve sex discrimination in law, not First Nation band membership codes. Third, Canada's failure to resolve the matrilineal descent sex discrimination actually establishes a colonial and patriarchal foundation in land claim and self-government process in that the descendants of Indigenous women are marginalized and thus vulnerable in the process. Genuinely respecting the nation-to-nation relationship would abolish the sex discrimination inherent in the 6-1A and the 6-1C hierarchy. Fourth, in fact, contrary to the claim that there is a need to respect the nation-to-nation relationship, Canada is not doing that at all. In the Algonquin land claim and self-government process, we're only being offered 1.3% of our land and a $300 million buyout. So that's not nation-to-nation. There's so much wrong with that. And fifth, the thing that I really want, the fifth thing I want to speak to is the argument that it would be irresponsible for Canada to implement the 6-1A all-the-way remedy without further analysis. It's my position that the claimed place of potential irresponsibility is actually an excuse that has been carefully constructed through decades of intentional and strategic deception and maneuvering rooted in the need for Canada to eliminate Indians. The Canadian government has been completely aware of Indigenous efforts to remove all the sex discrimination. This is not new, not at all. Canada has had decades of time, as well as the deep pockets of money required to accommodate the research needed to draft legislation that would remove all the sex discrimination and bring about Charter compliance. Instead, what Canada has done is place its time, dollars and efforts into crafting legislative amendments that ignores, confounds, disguises, and for that matter, crafts silent forms of sex discrimination, such as what we've learned from Gale versus Canada. In this process, INAC has in fact crafted new forms of sex discrimination versus ensure the Indian Act is charter compliant. It is my position that Canada's claimed position, it would be irresponsible to move forward without further analysis, is more about disrespecting what is genuinely a nation-to-nation relationship, and it is the complete manipulation of Indigenous women's agency, Indigenous women who are already burdened. I ask members of the committee to support the amended version of Bill S3. It is crucial to upholding the human rights of Indigenous women and their descendants, and to finally putting Indian women and their descendants born prior to 1985 on the same footing as Indian men and their descendants born prior to 1985. Please stand with Indigenous women's call for charter compliance and equality. Miigwech.
Thank you very much. And our third panel, or our third group in our panel, is from the Quebec Native Women's. Welcome.
Madam Chair, ladies and gentlemen, members of the committee, Vice Chair, good day. I would like to thank the Anishinaabe Nation for allowing us to be here on its vast unceded territory. Quebec Native Women is an autonomous association which was founded in 1974 to respond to sex-based discrimination in the Indian Act for more than 40 years now. Quebec Native women have been working strongly together to denounce this paternalistic, assimilationist, and colonial law. Our position has always been clear, and we remain firm in our claims. We require that the Government of Canada remove from the Indian Act all discrimination that is on the basis of sex and anything related to it. We claim our right to grow amongst each other, with each other, practicing our languages and culture, transmitting these to our children and future generations. Since 1982, Canada has based its activities on a constitutional charter of rights and freedoms. There is no higher law than the Constitution and this charter, which provides for basic laws and respect of all Canadians, including Native peoples and First Nations. Included are the right to non-discrimination based on race or sex. As for the discrimination that is in the Indian Act, it's clear that we need to ask why such a law even exists in Canada at this point. This country that's now about to celebrate its 150th anniversary of Confederation. What are we waiting for? Native Women of Quebec was present at the 16th meeting of the United Nations on Native Rights, Indigenous peoples, and we deplore the current situation here in Canada, specifically with regard to Native women. So many women have been torn from their families, their communities, have been uprooted and lost their identity because Canada set up and is now struggling to maintain in place a violent law based on sexual inequality and on race. We find it deplorable that in 2017 we still must meet to fight against this legislation that renders us inferior, that discriminates against us both as women and Native women. This is dual discrimination, whereas our Native societies traditionally held that women were a great gift. Now, in the mind of many of our people, a woman's life is not worthy of that of a man's. We are assaulted, we are treated violently by the state and now by the population, and people get away with it. The UN Declaration on the Rights of Native Peoples and the Inter-American Statement on Human Rights have both concluded that discrimination based on sex in the Indian Act is one of the main causes and fundamental causes of the violence that women and girls now face in Canada if they are Native. So Native Women of Canada insists that the House of Commons respect the Constitution for all women, in particular for Native women and their descendants who have been hidden, kept aside by governments who wished to do away with Indians and the Indian problem in Canada, even if that meant that there was not a single Indian left standing on this land. Thus, Quebec Native Women requires that the government accept 61A and use it fully. We also require that the government of Quebec put an end to discrimination based on unstated paternity. Women have a right not to state the name of the father on a birth certificate without this penalizing the child. No one should have the child penalized, and no one else faces this in Canada just because the father isn't known. Why should this apply to First Nations women and children? Third, Quebec Native Women requires that the government put an end to the use of categories 6.1 and 6.2. Since 1985, these categories have led to a number of various types of discrimination. For example, within a very same family. Think about it. Would you like some of your children to be held to be Canadians and the other children not, because they were born after the 17th of April, 1985? It makes no sense whatsoever. As many other representatives of our nations have said before us, the complete elimination of sex-based inequities in registration would not be possible without the changes I've just outlined. Bill S3, adopted without the amendments proposed by the Senate, including the elimination of 6.1 and 6.2, would just keep the Indian Act as discriminatory as before. Quebec Native Women has heard the government often say that we need a second phase of discussions and consultations that would be longer and allow for more discussions on these claims. It seems aberrant that the government has actually waited so long to act on this now for 5 more months, saying that they need to consult more, and this merely shores up their overall inaction. It's a pretext. We feel that the government must consult Native peoples. Yes, there is a duty to consult, but not in the circumstances here affecting S3. Quebec Native Women reminds the government that the government cannot hide behind such concept of duty to consult to avoid changing something which is contrary to the Constitution. We feel that the government need not consult communities to tell whether it need to put an end to discrimination against women in a charter sense. Let's be honest. Everyone knows that the Indian Act is discriminatory. We all know what would be needed to put an end to that discrimination. Basically, this is not a lack of knowledge, but a lack of will, of political will. Sandra Lovelace, Mary Tuax-Thurley, Sharon McIver, Lynn Gale, and so many other women are able to tell you exactly what sort of discrimination women and their descendants are subjected to. A report in April produced by the Native Association Women's, during the further consultations on S3, was tabled to INAC, detailing the effect on women of S3. And that's what we are speaking to today. Women have had enough. They don't want a second phase before anything changes. The government is now saying it would spend 2 years in a second phase. Could you tell me what you intend to discover in 2 years that you don't know already, what you haven't known for the last 30 years? Native women are patient. They are resilient. They know they have to repeat themselves several times, and we're repeating ourselves again before you here today. It is your duty to hear us, to listen to us and hear us, and take action. We remind you that the act as it is paternalistic, assimilationist, and colonialist. We tell you that we are afraid of it. We are afraid of people using it. We have suffered from it being used against us. Residential schools, of course, have had an impact. We know that. The history of colonialization have left their mark on us. There are already so many wounds that are open that need to be attended to and heal between us and within us, each of our peoples. The government must see to it that together we can foresee the future, a brighter future for our people. The Native Women of Quebec speak up, asking you once again and for one final time to put an end to discrimination based on sex so that our women and future generations can truly heal from the assimilatory policies, the residential schools, the genocidal policies of the past. We require that you deal with 6.1a as of 1800 and eliminate 6.2 as a category. You continue to speak of reconciliation with our peoples. Reconciliation starts here and now. It starts by giving women the rights and the position that the government has taken from them. We require that women now and in the future no longer need to fight for their basic rights to equality. Let us work together to create a world where our young people can once again understand what it means to be Anishinaabe, Atikamekw, Mohawk, Naskape, Wendat, Malesif, Mi'kmaq, Inuk, and so many other identities, rather than leaving them in a void where they lose any sense of who they are, losing their sense of existence as they fight continuously against an assimilationist law, the Indian Act. You are not responsible for what other governments did before you, even what your ancestors did to our peoples, but you are responsible for this situation today if you decide to remain complicit with the forced assimilation of our peoples by avoiding moving ahead on what you need to do now and what you have been told you need to do now. You have a power to decide things for us. You took that power. We never gave you that power, so hear us. Thank you for taking the decision that you would take for your own wives, your own children, and your own descendants. Be among those whom we will remember in the future as those who truly worked for reconciliation between our peoples and not for those who prolonged the loss of our languages, our culture, and our very identity. In the name of the Native Women of Quebec, our ancestors and our futures, I say thank you. Miigwech.
We are moving to questioning. This round is 7 minutes. So an MP will start off. They'll have 7 minutes to ask a series of questions. Please direct your questions either to the panelists in front of us or to the individual on the phone, Chief Picard. So MP Ananda Sangri, please.
Merci, Madame President.
Thank you to our witnesses
Today, and thank you for your very considered submissions. I think there's based on the testimony of the three panel, there appears to be a contradiction, and the contradiction is, on one side, it is not the role of the federal government nor anyone else outside of each of the communities to define what membership is and who ought to be a band member. On the other side, we're dealing with a piece of legislation. We're almost forced to deal with a piece of legislation and amendments to it because, as is the Indian Act, is discriminatory on many levels. And Madame Michel, you've outlined it eloquently, but particularly with respect to sex-based discrimination. How do we resolve the contradiction? And how do we make sure that that this legislation addresses a response to the court decision in Deschanel, but at the same time ensures that there's a path towards individual communities to make the decision with respect to band membership? And I'll start with Chief Picard and Chief Norton, and then to Dr. Gao.
Well, for myself, it's pretty straightforward. What you call contradictions in positions is not necessarily that. The way I view it is the Mohawk Nation is not the same as the Algonquin Nation, as the other nations. They have their own historical relationship with Canada and their historical reasons for doing what they have to do, and so do we. In our approach, in recent months was to increase our activity as much as possible. We do not want to be in conflict with anybody, any one of our fellow chiefs or representatives in any way. That's not our
Chief,
purpose.
just to clarify, I didn't mean that there was a conflict. I mean there's a contradiction in the sense that we
Yeah.
need to do two things at the same time, and how do we do that? And
I
that's the
understand that.
question.
So you can't, and for me then, to be very brief about it, you can't use a cookie cutter approach. You can't. You have to find solutions for individual communities or nations according to what they believe in, or organizations such as the Autochtone, the Femme Autochtone de Quebec, or the national organization. And for us, the Mohawk people, is different. It's not the same.
Madame Michel.
Évidemment,
Well, clearly, we can see that there is a contradiction. It's in full view. What I want to say is based on your actual legislation. It is said, divide to rule, divide and conquer. I can understand that various communities have various realities that they must survive. They must find enough money for housing, that they're underfunded, and so on. I understand that whole overview of communities. I work with my colleagues, male, at the Assembly of First Nations. I have lived in a community. I know what all this is about, the culture, the languages. But today, we are addressing a problem for women, their very existence. Why were women particularly targeted by this law? Because we, as women, are in charge of transmitting language and culture and seeing to it that they survive in future generations. Let's look at the context. Why, before 85, a Quebec woman who married a Native person was found to be a pure Native woman, and so were their children. How odd that is. So the ultimate aim of the Indian Act truly was to assimilate our peoples. And who bore the burden of that? Who was penalized? We, the women, because we bear the future generations. We are the guardians and the stewards of our language and culture. Of course, that leads to contradictions that we see clearly today, but we now must speak for the women. The basis of this contradiction is this Indian Act based on discrimination and targeting us. If we want more of a collectivity, more of a community, yes, of course there are many issues to make sure a community can survive healthily. But when I walked, because I walked from Quebec to Ottawa to support our intervention on C3, and I understood why my colleagues and others of our brothers and sisters were wondering whether they should support us or not, because even though the 40,000 Moo Indians were entitled to register, we would have had the same budgets to deal with the situation. This is about survival. That's a big deal. Survival. Why is it in any case that you recognize who we are? We are not in a position, we're not permitted to recognize each other and ourselves. That would have made a big difference, and our nations would all be better balanced if that had been the case a long time ago, of course. If you will allow, I would like to add something to what Ms. Viviane Michel has just said. She is right. Her conclusion is correct. We do not have the right to decide who we are and who is among us. That was removed from us, that right, in the 1800s, and the government took that right to itself. Now the government cannot simply wash its hands of all responsibility for what occurred because of this. We agree that we have this right. Indeed, it is part of the UN Declaration on the Rights of Native Peoples, but you have right now the responsibility of undoing the ill that has been done, the harm that has been done, in particular to our women. That is your responsibility. Once you will have carried out your responsibility, as Michel has said, then we will all be able to sit down and discuss about futures and who can become members of our communities.
Your Dega.
Thank you, Madam Chair, and good morning to our guests.
Once S3 receives royal assent with or without the amendments, how do you envision Phase 2 to roll out, and what are your expectations? And I'd like to hear from each of our presenters this morning.
I don't want to comment on that, thank you.
Would you repeat that again?
Once the S3 receives royal assent and it goes into Phase 2, how do you envision Phase 2 rolling out, and what are your expectations from Phase 2?
I'll be saying the same thing I'm saying here today. It won't be any different for me.
Okay. Okay, so I'll move on to the next question. Okay. Yes. Go ahead.
En ce qui concerne la deuxième phase.
So, speaking about the second phase, I think Quebec Native women does not feel that a second phase is needed. We don't need to be consulted about a discrimination that exists and must be completely removed from the Indian Act, which is a Canadian law. Do you consult people to ask them, do you accept being discriminated against? It's not logical. In fact, it's ridiculous. We don't need to go into a second phase of such discussions that would last, 2 years? We've been at it for 30 years. You've been hearing women and nations and communities telling you what's going on for 30 years now. You know what the reality is and what the impact of the law is based on what we've already told you. So, when you've heard year in and year out what needs to be changed in the Indian Act, that's something that has been covered in a Phase 1. If there's a Phase 2, and of course that's an if because it's uncertain that there will be such a phase, but should there be a second phase, once the discrimination issues will have been settled, as they should be at Phase 1, then we will be able to sit down and talk about how we can move out of the Indian Act. Will always remain exactly what it is, assimilationist, colonialist, but that would be an appropriate way of viewing Phase 2 and the discussions to be undertaken within it.
Anyone else want to comment on my question? Okay. My next question will go to Chief Norton and Chief Picard. With the potential of doubling the amount of individuals with Indian status, will this be a financial burden on First Nations who want to accommodate those who wish to relocate and become band members?
I touched on that earlier on in my opening remarks. That would actually, in our situation, double the numbers. Now, mind you, you can take those numbers that are registered here directly with the Quebec, the Canadian government, Ottawa, INAN, in terms of the process that's in place now. Some of those people are probably eligible under our criteria. Right now, our process is frozen for a time period. Others would want, and I can't give you exact figures, but a percentage of those would want to come back into the community for sure, for housing, education, land, and all the things that they feel they're entitled to. There's probably a set number out there who will never show up, will never come back to the community. But it's still a worrisome situation because as it is right now, you know, we have to double our efforts in order to provide the services that we do provide. It creates an uncertainty for the future in terms of the existing people now in the community and their fear and their concerns about people coming in who know nothing about us, who understand nothing about us. It's part of what we call the ethno-cultural suicide, if you want to call it that, for something like this to happen.
Chief Picard, would you like to comment on?
Well, yeah, the only thing I will add, thank you for the question. Can you hear me okay?
Yes.
Okay. Well, Obviously, and again, I think it's important for the members of the committee to know that Quebec is no different from other regions where there might be different point of views on this issue. And again, as I stated earlier, a very delicate matter, very sensitive. And I'm tempted to say that it's been a burden since '85. And this is a reality where you have a government transferring the onus of applying, in this case, a court order to the communities. And so, in a sense, transferring the liability to chiefs and councils. And that's totally unfair. And it's probably, still very many arguments to be made in terms of the impacts. But you just look, 30 years behind, and you see the kind of instability that, this issue has caused for the past 30 years. And again, in many cases, clearly pushing leadership against the wall. Even within our region, even those chiefs who might be in favor, of putting an end to discrimination against women, there's also a big part of them that says, okay, well, then what? And that's where I guess some chiefs find it very difficult to provide a response where they know they don't have the capacity. And so they're going to be, no matter what decision they take, they're going to be liable. So there's that issue, I think, at play here. And again, it's like it's a never-ending cycle of intervening before the court.
Thank you very much, Chief. We have to move on to another round of questioning, which goes to MP Saganash.
Miigwech nistam juit matno nastawe sediasian tunskom nom shwe kadukshinyag bedayagya state muno uda miigwech tudno. I think everyone on this committee realizes or knows about my total, absolute disdain for the Indian Act. But we have to deal with it. It's still there until it's gone. Mais j'aimerais d'abord poser une question.
Allow me to ask a question to Ms. Michel, because, by the way, I first want to thank you for your testifying before the Commissioner, the investigation in Val d'Or regarding the relationships between the Native peoples and some of the public services. Thank you for your testimony there, which was much appreciated by so many. So Canadian Native women and Quebec Native women made their concerns very clear in a testimony at the beginning of this week regards to Section 18 of S3 16, Recommendation 16 of S3, saying that no one can claim damages if they have not received redress before the law came into effect. So it's a non-responsibility or clause for the Crown, which exonerates the Crown from responsibility. And Canadian Native women had a serious problem with this. I'd like to know what Quebec Native women thinks about that clause. We support the concerns expressed by Canadian Native women. We had mentioned this during our first representations when S3 first came out. And we remain very concerned about that clause, which I believe was Clause 8 at the beginning, but now is Clause 10, yes. But the clause exonerating the government from responsibility was also mentioned by other women and other Native organizations, and it is a real concern, this Clause 10. It's a very big concern for us as well. This is the only law in Canada that allows for discrimination without the government bearing the responsibility for that discrimination. That's nonsensical. I think that we both agree on that. Thank you for your answer. Because listening to you earlier, I heard you say that yes, the government has a responsibility and must repair past harms. And that, to me, seems indeed to be a real breach of the requirement to respect a law.
The reluctance of the present government to move forward with 6.1A all the way. Et je pense que Mme Michel l'a très bien.
I believe that Ms. Michel has underscored this as well.
Further, is there any justification to continue to consult with Indigenous peoples, whether or not they would like to be discriminated against further? I mean, that is such a ridiculous pretext not to move forward with S3. I'd like your comments on that. Lynn, perhaps?
Yes. I do think it's ridiculous. I think that who are they going to consult with? First Nations, where the descendants of women are missing? That's not nation to nation. But I think what we need to keep in mind is we're asking that they change a law, not ban membership. And also, I think the only thing they really need to consult is the Charter. The Charter gives excellent guidelines to ensure that sex discrimination doesn't exist, and it's my understanding that in enacting laws, Parliament has a responsibility to be acting proactively versus just acting after the fact for back-end fixes. So that's mine.
Madame Michel,
And Ms. Michel, do you feel that your fundamental rights as a woman and the fundamental rights of Native women are still up for grabs? Well, there are people who are making decisions without having really sat down with women to talk with them. Some feel that changing the act based on their own view of it will be the best, and they haven't necessarily fully considered the effects that would have, and there are contradictions. And that indeed is the heritage we are living with, the results of past actions that we are living with, and we'll have to continue to deal with them if things aren't handled properly now. If the amendment is accepted, we will still have to carry out a good deal of reconciliation among us. We have been so broken. We have been broken by this legislation. We have been sidelined. And of course, I don't want to go over our history, the history of the First Nations within Canada, but we tended to work on equal footings in the past. We had very equal relationships between men and women, and this changed after colonization. What was that due to? I think now there are fundamental rights that must be respected, and that must be based on respect. Indeed, respect is the right word. 30 years, you've been hearing women say that they are discriminated against. Now we need another 2 years for something called a phase 2 for you to hear exactly the same thing you've heard for the last 30 years.
We're moving to another questioner who is MP Remy Massé.
Merci, Madame la Présidente.
Thank you, Madam Chair. I will ask my questions quickly because I have only 5 minutes this time round, and I would like to ask you to help me clarify a few of your positions. So, Grand Chief Norton and Chief Picard, in the letter that you have submitted to us that we have advised ourselves of in the last few minutes, you mention the ramifications, the considerable ramifications of the Bill S3 as it is now phrased. First question, are you referring to Clause 61A all the way or completely applied? Are you referring to the various changes applied by the Senate or to you, Grand Chief Norton and Chief Picard first?
But if it's to what I would consider tinker with the Indian Act to meet certain, I guess, goals and criteria, I would simply go back to you and say, why doesn't the government recognize the fact that the Iroquois people have their own way of identifying their people through clan systems, through naming their own people, identifying them, and some kind of nation-to-nation understanding is reached between the parties in order for Canada to say, this is the way they do things with the Mohawk Nation or with the Iroquois communities, you know.
Ma question, pour être très précis, c'est...
My question, to be a little more precise, is, well, obviously, given that this is a legislative process that's underway here with a Superior Court of Quebec request that changes be made to the law, and of course I don't like using that term Indian Act, so let's just say the law we're discussing. Do you think the government should indeed work stage by stage, that we should settle the issue that we have been asked to settle based on the Duchesneau decision, that we settle that first and go ahead with a act that we agree on here at the parliamentary level, and then go into a consultation to address the broader question of discrimination? So do you agree that the government should go step by step, settle this part of the problem, and then go on to a broader discussion? Thank you for your question, sir. Am I heard? Yes, I'm hearing you. Thank you. Well, given that we have little time here, it's difficult to give you a detailed response to your question. And that's why I was going to say a little earlier that over and beyond our presence before you today, myself by telephone, we will be providing the committee with a more detailed statement by the end of the day tomorrow. But that said, the question you're putting is relevant. This is a source of concern. And the concern is shared broadly among chiefs in Quebec and Labrador. There are a number of issues we do all agree on, despite the difference in some regards. We were contacted last Monday about appearing before you this morning. Sometimes we have the impression that when, it's a state of panic that's overtaken the discussions, then people come and ask us what we think, but not until then. Last year, a decision was taken very early in the year, and the first consultations did not take place until September of last year. And had we moved faster on all this, we might have been able to work out some answers. As for the step-by-step process, Grand Chief Norton has mentioned something about it. And all chiefs are discussing the potential impact that the decisions may have.
Miigwech, thank you for coming out. That concludes this first round of questioning and presentations from you. We sincerely appreciate your efforts to come here in person and for you to come on the phone. Merci beaucoup. I want to thank you for participating. We're going to suspend for a couple minutes so that the other delegations can take their seats and get reorganized. Do you think so? Yeah, thank you. Other parts of improvement. Oh, I need to be a little bit assertive because we have many presenters that want to have their voice heard. And so I'm going to ask members to grab their coffee, come back to the seat. Let's get going. And on this panel, thank you for coming, we have Sharon McIver, Pam Palmer, and Catherine Twin. And each one will be allowed 10 minutes, if that's our standard, unless I hear otherwise. 10 minutes to present, and then after that we'll go into a round of questionings from MPs. And if we go according to my agenda, we start with Sharon. Welcome.
Good morning, and thank you for inviting me today. My name is Sharon McIver. I'm in Laketmuk from South Central British Columbia. I've been working on this issue and many other issues, but this issue for almost my entire life. And I just wanted to start off by saying that there's an understanding that the oppressed and those who have been discriminated against have never gotten their freedom or equality by asking those who have oppressed and discriminated against them. So I'm just wondering, what the heck am I doing here? Because this issue has been going on for many, many years, you know, way longer than the 30 years. We're talking about 525 years for us where immigration has seriously interfered with who we are. 525 years. And as you know, 150 years where the immigrants have had the ability to make laws that lock us into a position where we cannot move. So I understand that the communities are suffering, but the communities aren't suffering because of the women. They are actually suffering because of the lack of their women. I also wanted to say that I'm listed on the program as an individual, and I want to make it clear that I'm not only speaking for Sharon McIver. I'm speaking for Mary Tuax Early, Jenny Margetts, Nellie Carlson, Susan Blankenship, Etta Blankenship. The list could go on for a long time. I'm also speaking for Jeanette Corbière and Helen Blankenship and all of those that are still alive that have had the Indian Act and the operation of the colonial government affect their lives so, so badly. And I also want to talk a little bit about, well, who are you speaking for? You know, in theory, you're speaking for the Canadians because they've elected you and put you in place. But if you look historically, John A. Macdonald was a racist and a sexist, and when he was Prime Minister, a lot of these policies got their teeth and they started affecting the Aboriginal communities, and in particular, the Indian women. And the bureaucrats, Duncan Campbell Scott was a very famous bureaucrat that worked very hard throughout his tenure to make sure that as many as possible Indians lost their right to be recognized as Indians. So now, today we're talking about a piece of legislation, and as some of you probably know, I've been here before on this matter, that C31, C3, S3, and all of the different changes that have been forced by the court. I've also been around and been involved for a dozen of ministers of Indian Affairs. I talked to, for example, Minister Irwin about the matrimonial property issue, the matrimonial on reserve property issue, and he said, Sharon, I'm a family court lawyer and I know the issue and I know it well and I know it's not good, but I can tell you I will not touch the Indian Act with a 10-foot pole. So we know you're forced to be here because Desjardins. You were forced to be there because of McIver. You were forced to be here because of the Charter Equality Rights section kicking in. So I think the 10-foot pole analogy has worked itself out really well. And I can tell you, until you get another court decision, you won't be back here. You can promise all the promises, because you did. In 1985, you promised they would go out and consult, and apparently you've got in your files, in your archives, 20,000 documents that prove that the communities agreed to leave the discrimination in. And when we went to court, those documents were used as a justification for keeping me out of the courtroom from July of 1989 to October of 2006. And we finally were able to get to trial. We never did have disclosure of those 20,000 documents. We still have no idea of what the content of the documents that gave the justification to continue the discrimination against the Aboriginal women. And when I went to court, I was the Government of Canada put forward that they had looked over all of my history and decided that, in fact, I was entitled to status good enough to pass it on to my son, because my son and I were in the case together. And I was a 6'2", which meant I didn't have the right to pass it on my own, and my husband was white, and my son did not have status because of my 6'2" status. So they came to us in July of 2006 and said, oh, we've looked at the records, and we've discovered that you are in fact entitled to better status, and your son can have 6'2" status. And they said, now the case is moot, and let's all go home. And so we refused to do that, and in September of 2006, they brought a case, a motion to have our case declared moot. And they did not succeed in the motion, but at that time we asked the court to declare that my son was entitled to status, because that was the justification they used to have it declared moot. And the court refused, or actually the Crown refused to consent to my son having status. So they were using it for justification for having the case declared moot. They refused to consent that he could have status, and because we had not put an application in to have the declaration, we needed consent of both parties. So he did not get status in September of 2006. When we went back to court in October of 2006 for trial, we did bring the motion, and it was heard first by Madam Justice Ross. And we didn't have a clue how they figured out why I would have better status to pass it on to my son. And so what happened was we asked Department of Justice to argue our motion for us, because we didn't know how they figured it out. And they said that I was entitled to status because my grandmother, who was always a status Indian for her entire life, was not married to my grandfather. Therefore, my mother had status at birth. And my mother was not married to my father, so therefore I had status at birth, and I lost my status in 1970 when I married my white husband. Therefore, I came back as a 6'1"C. That was that, the married out women got a 6'1"C status. And my son was entitled to 6'2" status. So that piece is the one I want to talk to you about today, because in 2006, I got 6'1" status. My son got 6'2" status. My brother, who had did absolutely nothing on this issue, got 6'1"A status. And his first wife in 1972 and his second wife in 1983, both white women, were entitled to 6'1"A status. And my sister-in-law, in fact, in 2007 got 6'1"A status. A white woman got 6'1"A status. And this was in 2006. We didn't resolve ours until 2010. So all I wanted to say is that the operation of the Act is still giving white women status, 6'1"A status, and I can't get 6'1"A status.
Thank you. You presented that very clearly and passionately. I think we understand. Now we're moving on to Pam Palmater, Chair of Indigenous Governance, Department of Politics and Public Administration at Ryerson. Hi, Pam.
Hi, Kwe Nindaluizi Pam Palmater. I'm from the Sovereign Mi'kmaq Nation on unceded Mi'kmaqi territory. And I'd like to acknowledge that we are here on unceded Algonquin territory as well, which carries a huge responsibility. And I hope that every one of the committee members recognizes what a historic moment you are in. Today, in this room alone, we have Jeanette Corbière-Laval, who took Canada to court on this issue. We have Senator Sandra Lovelace-Nicholas, who took Canada to court and won on this issue. We have Lynn Gale, who won on this issue. We have Sharon MacGyver, who won on this issue. And unfortunately, Yvonne Bedard isn't here, but we have Stéphane Deschanel, Susan and Tammy Antha, and there's many more in the hopper. How many more times are you going to require that Indigenous women spend their entire lives trying to get equality in a country that equality is actually the law? You don't have a choice here. This committee, in fact, should be moot. This is something, a very clear message, and the fact that the government or any committee would be wondering or considering delaying equality for one more day shows exactly how ingrained sexism is in this country, and for Indigenous women, racism. Because it is the law. You have no legal choice but to pass this bill. None whatsoever. It's not a matter of whether someone likes it. It's not a matter of whether the male organizations like it or other people like it. We have equality for same-sex partners in this country. There were no demographics done. There were no cost projections done. You didn't bring in people who are anti-gay. It's a matter of equality. You do it because it's the law and you have to do it. And as democratic people in a just society who values equality, you come together and say, we will bear whatever the cost, whatever the implications of ensuring that equality. For Indigenous women, however, it's a little bit different. It's a matter of life and death. And that's the difference. This isn't just a matter of administration. What phase will we do? What kind of funding agreement will we have with the AFN? This is a matter of life and death. It should be a done deal. And here's the other historic part about Bill S3. When have I ever come before any committee ever, or written about any federal legislation and said, I support this bill? You can count the number of times on one finger, and there's a reason for that. Nobody wants the Indian Act. Nobody wants paternalistic, racist, sexist government telling us what to do anymore. And oftentimes this happens without our consultation or consent. However, this is a piece of federal legislation which is subject to equality laws. You don't have a choice here. But Bill S3 is historic for another reason. It represents the consensus of the Senate. A non-partisan consensus. How often do we get that in this political country? I would offer not too often. You also have Senator Murray Sinclair, who is the head of the Truth and Reconciliation Commission, who is the expert on how to bring about reconciliation in Canada, who I met with yesterday and said, Pam, please remind this committee that he was in favor of this bill. And in fact, he doesn't believe it goes far enough. But he is in favor of this bill. And that is significant. There is no oppositional outcry. That is also very significant because INAC has worked very, very hard in the last 6 months to manufacture dissent. And money is very powerful. You can go to any Indigenous organization and say, listen, support us on this, and we'll give you millions of dollars in phase 2 to talk and talk and talk and talk, something we've done 100 times. Well, here's what's the relevant part. No national or regional organization is a rights holder. They're not a government. They have no say. It's the people who are impacted that have a say. So they may sell us out for consultation money, But that's beside the point. The law still applies. And the core issue is, in fact, equality. It's not just Section 15 of the Charter that guarantees equality between men and women, or Section 3 of the Canadian Human Rights Act, which specifically prohibits the federal government from discriminating between men and women. Section 35(4) of the Constitution Act is very important because you often look to First Nations to say, well, what's your view? It's your Aboriginal right to determine citizenship. Do you want to discriminate against Indigenous women? Well, Section 35(4) says if you're going to assert an Aboriginal right, by the way, it's guaranteed equally between male and female people. And in case that wasn't clear, the international consensus under Article 44 says that every single right in the United Nations Declaration on the Rights of Indigenous Peoples, which Canada supports without qualification, is subject to male and female equality. Most importantly, there isn't a single Indigenous law or legal system in Turtle Island that justifies or sustains inequality between human beings. Needless to say, male and female people. Our treaties guarantee these rights for heirs and heirs forever, not just the guys. And just because the male organizations have failed us, and just because they're not here advocating, doesn't mean that we are not entitled to that equality. And here's the hard part that you have. If you want to continue to be racist and sexist as a government, if you really want to, that's going to be hard, because you are going to have to take a complex set of Indian registration mechanisms and make it even more complex to make sure that you register the minimal number of people possible and that you maintain the legislative extinction dates for every First Nation in this country. If that's your goal, then you don't have the ability to talk about reconciliation, nation to nation, or anything else. And what you are saying if you don't pass this bill, if you do not stand with Indigenous women on equality, is Indigenous women, you don't deserve equality, but you must also accept the consequences. And that means it's on you when Indigenous women go murdered and missing, because the United Nations has already told Canada it is one of the primary root causes of murdered and missing Indigenous women, that it's okay for Canada to continue to steal Indigenous children from Indigenous women at rates that far exceed any other country in the world, overrepresentation in prison. And what you're telling serial killers and rapists is that you can continue to target Indigenous women at 7 times the national rate because you get to do it with impunity. No one cares, or we would have acted on this already. You'll also maintain the legislative extinction dates, and there's no reason for it. Enough is enough. In 2017, Trudeau said, promised a new relationship, nation to nation, based on equality and respect for Aboriginal and treaty rights that would end violence against Indigenous women. They would, quote, abandon the adversarial relationship and, quote, abandon forever the top-down paternalistic decision-making powers, and even repeal Harper's Laws, which I will remind you includes the very discriminatory C3 that came out of the McIver case. Words mean nothing. Phases, ministerial commitments mean nothing. Actions mean everything. And there is nothing stopping you. There is nothing in the McIver case, Lovelace case, Gale case, or Deschanel case that says you cannot remedy gender equality. And in fact, Justice Mass said, please don't do what you usually do. Please just fix this once and for all. And please do not buy into the federal government's fear-mongering among millions and millions of people being registered. That is a blatant lie. It is meant to fear-monger amongst First Nations, and it is not true. There are less than 900,000 registered Indians now. 50% of those are women, and 50% of those are children. Less than 100,000 people cannot make 2 million people. We may be baby makers, but we can't make 2 million people. So I'm asking that this committee support the Senate's amendment and not have any more delays in granting equality for Indigenous women. Thank you.
Thank you. We've got Catherine Twin, and with her, Deborah Sarah Finchin, daughter of the late Walter Twin, Chief and Senator. Welcome.
Good morning, everyone. I'm here today with my stepdaughter, Deborah Sarah Finchin. I prepared a genealogy, and also I do have written speaking notes, but this morning I forgot them on the table. I'll provide them to the clerk. I want to pass around, though, the genealogy of Deborah Sarah Finchin compared to other persons, and thank you. I want to make the point that Deborah is not a registered Indian, nor is she a Sawridge First Nation band member. On both sides of her lineage, she descends from treaty signer Charles Nisochisis. Her lineage is impeccable in terms of her First Nation status, post-treaty, and I invite you to compare her situation to the situation of, say, a non-Aboriginal woman who married in pre-Bill C-31, 1985, acquired status and membership, divorced long ago from the Indian husband, who then himself enfranchises pre-Bill C-31, and she and her child are registered status Indians and band members in Section 6(1)(a), while Deborah is not registered at all. It is not for want of trying. In 2001, Deborah applied to the Department of Indian Affairs, and she was told that there was a backlog, it was delayed. So she then applied to the Lesser Slave Lake Indian Regional Council, and that was in 2002. They administer the Indian registration program for INAC, and they're governed by a board of chiefs. She submitted her application together with DNA evidence that myself and my children provided so she could prove her paternity, because my husband, her father, died in 1997. And Deborah had just found him just before his death, as she did her mother just before her death. And she did not know her genealogy because she was placed in the child welfare system. The response that Deborah received was, you need to go to some of the Sawridge First Nation members, the siblings, surviving siblings of Walter, and get them to swear a statement that you are his daughter. That is ridiculous. She had DNA evidence. They, the surviving siblings, had no idea who he slept with and when. And their evidence did not exist on that point. They all were students at Indian Residential School, and this fractured relationships, and some of them had moved away a long time before. To ask that is oppressive. It's a form of administrative violence. And they were reluctant. They're reluctant because they're afraid of high impact. In 1985, I appeared before your predecessor committee in March on behalf of Treaty 8. And their brief, which was provided to the clerk, spoke at length about high impact. And there was a very real concern then. And Sharon McIver is absolutely right when she says that we have nothing but a trail of broken promises when it comes to trust us, we're going to follow up. They don't. This has happened 3 times. 3 times, you're out. Sorry, I think you said, okay, thank you. Now, I read on June the 2nd that the minister is opposing the amendments that came from the Senate on the basis of a concern about impact. And I want to say to you that that is disingenuous and dishonorable. And the Crown, Canada, the lawmakers of Canada, you, have a duty to be honorable in your dealings with our people. That is from the Supreme Court of Canada. A duty to be honorable. Now, it's disingenuous because we went after the Treaty 8 brief, my community, notorious community, seen as the gatekeeper. CBC, Fifth Estate did a documentary targeting my late husband as a gatekeeper. That came out in June of 1997, just before we were to argue an appeal resulting from the decision that came from the federal court in the first trial. And one of the grounds was a reasonable apprehension of bias, that the trial judge, in making statements that Indians were childlike compared to adults, compared to white people who are adult-like, that Indian men are the beads and buckskin boys just after the crown shilling, that oral history evidence is ancestor worship, propaganda at its worst. We succeeded on the appeal, but we were forced into a second trial. And in that second trial, the Crown participated vigorously, aggressively, and with a great deal of hostility towards us. They brought in 4 special interest groups and paid them to participate. Central to the litigation was impact, as well as nature's laws, Indigenous laws. What is it that we govern ourselves by? What are the legal norms that govern our behavior towards one another and towards all life? That's documented. I remember the Crown lawyer saying, "Where's your statute book? Your laws don't exist. We have statute books." That's the mindset. In any event, we never got to deal with these issues because there was an attack on the lawyers representing the plaintiffs. And I was one of them. And I lived in hell for 5 years. I bet you if I were to sit with Sharon McIver and some of the other women and we compared our stories, we would see that there has been a state-sponsored quarrel here that's gone on for way too long and it needs to stop. So it's disingenuous for the minister, in my opinion, to now say, oh, we're concerned about impact. You didn't follow up on impact in 1985 in response to the Treaty 8 brief, and you had an opportunity to deal with us on impact in the litigation, and you refused to. Instead, you turned your guns elsewhere. It's also disingenuous because Métis now under the Daniels decision are Section 9124 responsibility. We're all under the same tent. So what are we doing here? Moving the decks on the Titanic? Moving the chairs on the deck of the Titanic? Feds are responsible. 9124 for all Aboriginal people. So let's not play that game of whack-a-mole. With respect to INAC's position on services and programs, their long-standing position, am I done? 1 minute, is that these are not legally obligatory. They're at the pleasure of the Crown. Well, if they really mean that, then what are they concerned about? In any event, INAC is notorious. There's been Auditor General reports and many, many other informants about the inefficiency and ineffectiveness and waste of the programs and services they administer. Late George Manuel said 1 cent on the federal dollar actually reached the grassroots Indian. INAC disputed it and said, no, it's 10 cents. In any event, there's innovative solutions taking place. In Quebec, I'm informed by the McConnell Foundation that they have partnered with the First Nation community to address chronic housing shortages. They have developed an innovative financing formula that has led to the construction of over 400 homes individually owned without prejudice to Aboriginal collective title. They've also built a hotel and a trade school. Thank you.
Thank you. All right, we're moving on to the questioning, so you have an opportunity to expound on your points and others that MPs can ask questions. First round goes to MP Mike Bossio.
Thank you. Thank you very much for being here again. Thank you for your patience. The decades of dealing with this issue again and again and again and again. I have a personal friend, Dr. Marlene Brand-Castellano, who you might know, that also was treated in this manner, and it was rectified under previous legislation. But regardless, I've always found it appalling that this situation even exists. I was at a Women's Restorative Justice Symposium back in 2014. I didn't know this situation existed until Marlene and actually Mimi Dawn Harvard was there, and Monique Horn-Miller and Jeanette Corbier-Lavelle, who actually also testified here, and I got to see her again and had a conversation with her that day, and I was stunned that this situation exists. I mean, most people out there are not aware of this at all. I still am overwhelmed by all of the discussions and S3, and it was here and then it's gone to the Senate and it's come back and it's been amended, and just trying to wrap my head around this whole convoluted mess has been very, very difficult for a lowly MP like myself that just has not dealt with it for decades as you have, and understand it with the every fiber of your being, and are revolted by it by every fiber of your being. You can tell through your passion that's the way you feel about it. But I also know on the other side, I've heard from my own chief the deep concern that they have in their community of being overwhelmed. They do have a lot of people they're one of the reserves that is growing. It's growing substantially by outsiders coming in, and he's concerned about having not just the funds, but the funds definitely is one issue, but the human resources to be able to deal with an influx, a large influx potentially of people coming in. And in our suicide study, we've also seen that as being one of the key aspects of dealing with the social predeterminants of health is the lack of human resources and infrastructure in place to be able to deal with existing issues on many in many communities, Indigenous communities. And then you've got Senator Sinclair, who actually also has expressed concerns about 61A all the way clause because of some unintended consequences that could result from the clause as it stands today. And we've had testimony from Indigenous Bar Association. We've had testimony from NWAC as well, where there are some concerns. And I'm not trying to pit one against the other at all. All I'm trying to point to is that the government, the reality of the situation may necessitate doing this in a staged fashion. There are 35,000 people who have already been identified. I know you're not going to like this. I know it. I can see it already in your faces that once again you shudder at it. But if the process is there, the commitment is there, it is written into the act the commitment. It's not a case of saying that we don't recognize that the discrimination, the racism, and the system is appalling as it stands right now. But it is new legislation, the duty to consult, the duty to prepare, the duty to ensure that the resources exist to be able to deal with this to deal with this at all. Just because in reality the resources aren't there today. Do you not see some level of validity in once again having a consultative process? Not to justify that we need to rid us of this once and for all, but to lay out a framework so that we can implement this in a responsible way. And I'll open it up to all of you because I know all of you are just dying to jump down my throat on this. So please, by all means.
Thank you for your question, and no is the answer. There is zero comfort in a staged process. We've been in a staged process since the 1970s. Stage one was Sandra Lovelace. Promises of consultations and amendments to the Indian Act. That didn't happen. Stage two was McIver. Again, promised consultations and phases and amendments to the Indian Act. Didn't happen. Stage three, Deschanel. And then very quickly after that, stage four, Lynn Gale. Because now you can't keep up with the amount of litigation for the failure to deal with gender discrimination. How many more promised but never delivered stages will we get? And the legislation does not say, we promise to end gender discrimination in phase two.
Can I just add one further thing? Is there anything that could be written into the legislation to give you a sense of security that it was going to be followed through? Forget about just saying we're going to consult, but if there were timelines, if there were detailed commitments that we are not saying that we're not doing it, but is there anything we can put in there that would give you a certain level of comfort that this was going to finally end once and for all?
Yes, end gender discrimination and support the Senate amendment. When you get rid of discrimination, that is the guarantee. Promises of reporting is nothing. We've had those before. And quite honestly, you can move forward in a staged process to deal with Indian registration and band membership in general by passing this amendment. That's in the immediate term, or in the short term. In the immediate term, you engage in your promise process to talk about band membership and other issues. And then 3 is self-determination. That's longer term. That should be the 3 stages, but there should be no single day left of gender discrimination. There's no excuse.
Thank you.
Moving on to MP Viersen.
Thank you, Madam Chair, and I'd like to thank our guests for being here. I know that Catherine Twin does come from the most beautiful part of the country. I might be a bit biased on that, but yeah, I know. So I guess my question to each of the guests that we have here today, if the minister was sitting here right now, what questions or comments would you have for her? I'll start with Catherine and work my way down that way.
Well, what I would say to her is, doing the same thing over and over, expecting a different result is a form of insanity. And the consciousness that created the problem is not going to be the consciousness to solve it. And that that constitutional compliance comes first, comes now, and is a separate issue from impact. Impact, as I said before, is being used disingenuously and dishonorably. I think there should be an impact consultation, but I think it should be led by both houses, and it should be collaborative. It should have inclusion of the people who are impacted. One of the things that has been said over and over, and I'm sure this is not new to you, is that we are dealing with a lot of historic trauma that is being intergenerationally transmitted. And that trauma affects how people think and how they interact with one another. We have a complex problem that was created by colonial legislation, which means we need to work together to solve it. However, one of the scholars, Aboriginal scholars, Dr. Peter Menzies, and this is directed to you, Mike Bossio, has said that one of the manifestations of this trauma, it affects 4 interacting levels: individual, family, community, and nation. And one of the manifestations at the community level is an inability to reclaim community members. And I know that because if you look at the Indian Register, they have registered 503 people, human beings, to Sawridge. We only have 45 members. And only one of those members is a child. Where are our children? One of the most impacted groups by Bill C-31 going forward are the children. Many of them are bandless. This is unconscionable and it's dishonorable.
Thank you for your question. I would tell her 3 primary things if she would come and speak to the people impacted. Is 1, that a rigid, non-negotiable position is not only a sign of bad faith, it's a breach of her legal fiduciary obligations to act always in the best interests of First Nations, and that is supposed to include women. 2, that her continued refusal to address gender inequality is an abusive process. It forces Indigenous women to continue to keep going over to court to litigate the exact same scenario over and over again, and it's a matter of unjust enrichment. By the denial of programs and services and treaty rights, the federal government gets to keep that because they insulate themselves in the legislation from having to pay later. And finally, I would say that Indian Affairs using the fear tactic of ballooning costs to First Nations is a double hit of discrimination. They are using discriminatory chronic underfunding to First Nations as the reason to discriminate against Indigenous women. And that is just the epitome of what it means to be INAC, and there's no excuse for it.
I don't have a lot to add to that other than the impact or the cost of an amendment is not a consideration. The courts have been very clear about that. And so you want to delay, you don't want to do what you're supposed to be doing, and you're using an excuse, well, we might not be able to afford it. It's not a justification.
Deborah, did you have anything to add there?
I'm not a lawyer. I'm not into any of this. All I know is that I don't understand different statuses, 6-1A, 6-1, 6-2, whatever it is. Simply, as far as I'm concerned, an Indian is an Indian. I don't understand why there's different levels of status. My mother was Indian enough to be in a residential school. My mother was Indian enough to hide me when I was a baby because they would come and take unwed mothers, Indian mothers, children from them. So she hid with me. She left the hospital and hid with me because she was Indian enough for that. But she wasn't Indian enough to get status. She had to fight for it. And what has changed in 50 years? Her daughter is now fighting for it. And I don't understand it. I'm Indian enough to be discriminated against, but I'm not Indian enough to get status.
Yes. You have a minute left.
I have a minute left, all right. One of the interesting things about this is that we're dealing with an aspect of the Indian Act, and we're trying to I know I come from an automotive background, and sometimes the vehicle's just too far gone. You try to fix the wheel bearing, but there's a million other things that need to be fixed too. And so this new wheel bearing's going to get you another five miles down the road, kind of thing. Is there, in your perspective, is this just? Am I describing the situation correctly, Catherine?
Well, I've prepared a number of amendments that I would hope this committee would consider to make the car run. And they're not rocket science. But you have to have courage. You have to have courage. You have to have independence. You can't be beholden to your party masters. You got to do the right thing here. So I will be presenting those amendments. I obviously can't speak to those amendments, but I would hope that they would be considered, and they're easily doable well before July 3rd.
Thank you. Questioning now moves to MP Saganach.
Thank you, Madam Chair. And welcome and thank you to all of you on this panel. I appreciate very much your words. I want to start with something that you asked, Sharon. In your letter to the senators, you talk about the potential, the concerns that were raised by communities with the potential impacts of 618 all the way. You say in one of the paragraphs, and I quote, "As I have explained in the past, I take fundamental exception to this argument. Indian bands and communities have no legitimate say in whether the Government of Canada continues to discriminate against me and other Indian women because of our sex. The Government of Canada has an obligation under constitutional and international law and a fiduciary duty not to discriminate on the basis of sex, whether Indigenous bands or communities agree or not. By now, most Indigenous bands and communities do not wish to see discrimination on the basis of sex continue." End of quote. And then you asked in your opening remarks, well, you talked about the people that you represent, that you're not here only as an individual, but you talked about the other women that you represent here, which is pretty legitimate in my view. And then you asked in your remarks, speaking to us, who do you represent? Who do you speak for? Who are you speaking for? Which is, I think, the fundamental question here. Certainly as a member of parliament, I represent my constituents, but also as a member of parliament and as a legislator, I speak for the rule of law. I have a fundamental duty as a member of parliament to uphold the rule of law. And what does that mean? It means respecting the Constitution. And in our Constitution is the Charter of Rights and Freedoms and Section 35 Inherent Rights. That's what we are here for. And thank you for asking that question. And that's why, and Pam, you're right in saying that we shouldn't even be here discussing this. I absolutely agree with that. That is the reason of my total, absolute, and profound disdain for the Indian Act, because it's so inconsistent with the fundamental human rights of Indigenous peoples of this country, and it shouldn't be there. And I've expressed that whether it's in our Constitution or in international law, the United Nations Declaration on the Rights of Indigenous Peoples. Those rights are inherent. They exist because we exist as Indigenous peoples. I think that should be our starting point all the time, whether we discuss policy or legislation. So my question is fairly simple. You're recommending that we support this S3 as a committee and recommend that the government adopt, or the Parliament, adopt this legislation. I agree with that as well. I've asked a question previously on Tuesday to NWAC, and I again asked it to the Quebec Native Women's Association about Clause 10, which is the no liability clause in S3, which is, in my view, problematic because, we are essentially asking this committee and Parliament to justify past discrimination, past violations of human rights with this clause. So I want to hear each and every one of you on this issue. And what would you recommend with respect to Clause 10 in particular?
I'll go first. oh, I hate that. I yell in my own ear. Well, in 2010, this actually came forward as well. And when the amended bill, it came out of this committee, that they amended the bill to include a clause very similar to the one that we're talking about now. And when it went back to the House of Commons, the Speaker had ruled the changes out of order. But we had eliminated the no liability clause. And that was the only one that was not ruled out of order. So the government's response to it was to scrap the bill and start all over again. And so, because they had what they wanted, everything else morphed back except for that one. And so, of course, no one should be immune from paying for the offenses of any kind. You know, it would be great if I could say, okay, I'm going to do that, but I'm going to immune myself from any consequences of that. It doesn't make any sense, either legally or, you know, just common sense, that it shouldn't be there. You know, if we could remove that kind of protection from themselves, we would probably have laws that actually follow the law.
For this round.
Okay, so thank you for your question. Definitely that section should be deleted. We also recommended that the same section in C3 should be deleted. It acts as an incentive to allow the government to continue to discriminate with impunity until they choose to address it or are forced to address it on their good old time. And in my submission, I highlight that, and I can resubmit it here to say specifically that needs to be deleted because they all know that it's discrimination.
Very short.
It underscores a sense of colonial entitlement. It absolves, it undermines rule of law. The Crown and a First Nation exercising Section 10 authority are fiduciaries. They owe fiduciary duties to the people. They cannot be given immunity for their conduct because essentially then what you're enabling is breaches of the law, breaches of procedural fairness, and you're giving them a license to do whatever they want without consequence. It's wrong.
Thank you.
Thank you. MP INAN Sangri.
Madam Chair, I yield my time to Mr. McLeod.
MP McLeod.
Thank you, Madam Chair, and thank you to the presenters. I certainly appreciate the passion and dedication to this issue. And I actually took one of your sessions, Catherine Twin, on lateral violence. I think it was some time ago. So I did learn a lot from that session. I don't have a lot of time, and this is a big issue for me. In the Northwest Territories, I have 5 large Aboriginal governments that would want to have input on this. There is a real concern from my part that why are we here talking about it? Why do we have Indian Affairs acting like a Department of Immigration for Indians? I think Romeo put it well yesterday when he said there's more people being accepted into the country than would be impacted by this. But at the same time, Aboriginal people, Aboriginal governments in my riding expect to be consulted. They're very adamant about it on every issue, and that includes this. And I heard, I think it was Pam that you indicated that none of the Aboriginal organizations, national, should be consulted. They're not rights holders. So I got 2 questions. First of all, on that line, is there anybody that should be consulted as part of Phase 2 that you see would fit? And the question is to all of you. Is there any rights holders out there that should be consulted? And Catherine Twin, you mentioned that impact consultations should be led by both houses. Maybe you could expand on that also. How do you see that working?
We've actually run out of time, so if your comments could be very short. Thank you.
Thank you for your question. I think you might have misunderstood what I was saying. What I was saying that with regards to gender discrimination, INAC has been consulting for decades and decades, and you don't get to consult on whether or not to discriminate. On issues like band membership and funding and all of those other issues, of course you should be consulting with First Nations first and foremost, and all of those impacted. But what I was trying to say was that the national Aboriginal organizations or the regional ones don't have a right to sell out us on gender equality for money for a Phase 2 consultation on unrelated issues.
To be quite liberal and give you a chance to speak if you wish.
I think there's certainly parliamentary precedents in relation to, for example, the Penner Committee report on Indian self-government. That was a special all-party committee. I think only of this House. I don't think it was both houses. But I think the lawmakers have to become fully engaged, and I don't think INAC can or should lead it.
Okay. We're going to have to cut off the debate here. Thank you so much for coming out. I appreciate the effort to come out on short notice and talking about issues you've talked about over and over again. Miigwech. First of all, I'd like to thank the Department, Indigenous and Northern Affairs, for coming in, and especially the Minister, the Honourable Carolyn Bennett. I believe all members have received your notes or copies of the speech, and as soon as you're ready, we'd like to get started. Thank you.
Somehow the hydraulics is just... Stand up.
Never happened before, but you could stand and present. Oh, there we go.
Chair, so keeps wanting to send me below the table. Hey. Anyway, thank you, Madam Chair. It's great to be back at committee, and thank you for inviting me here to talk about Bill S3 as we acknowledge that we come together on the traditional unceded territory of the Algonquin people. thank you also for understanding the urgency of this bill and also for your work during this pre-study. As you know, in response to the recommendations of the Standing Senate Committee, the government sought and was granted a 5-month extension to consider S3. Through the additional time provided, there have been numerous improvements made to the original version of Bill S3, which the government has welcomed and supported. The bill now proactively addresses further groups impacted by sex-based inequities, which were identified by the Indigenous Bar Association. The recent Ontario Court of Appeal decision in the Gale case has also allowed the government to address the issue of unstated paternity by enshrining additional procedural protections in law through this bill. In addition, I acknowledge the understandable skepticism of First Nations impacted individuals and parliamentarians about whether the second stage of registration membership reform will actually lead to meaningful change. That is why in this bill we are proposing a series of amendments to report back to Parliament on a number of occasions and in a number of ways to update you and all Canadians on our progress towards broader reform. 3 separate reports to Parliament are now in this legislation. On the Stage 2 process, I need to know that I am committing personally on behalf of the government to co-designing a process with First Nations, including communities, including also the impacted individuals, organizations and experts, to deliver substantive registration reforms, including potential future legislative changes. This will be a process where the voices of the full range of impacted people will be represented at the table and which will incorporate a human rights lens. I want to be clear, in Stage 2, Charter compliance will be the floor, not the ceiling, and there may well be areas of needed reform where there is no consensus to be achieved. The government has made it clear that consensus will not be a prerequisite for action. However, if the government is to act absent consensus, it only increases the necessity for decisions to be based on a foundation of meaningful consultation engagement and credible evidence about the potential impacts of reform. Balancing the needed time to engage impacted people with that for parliamentary processes has allowed only 2 truncated 3-month engagement periods, even with the extension granted by the court.
I think that given the context of the limited engagement possible within the court-imposed timelines, it is important to address the intended scope of Bill S3.
Is to remedy the known sex-based inequities relating to the registration of the Indian Act, which fall short of Charter compliance. This is not restricted to situations where a court has already ruled, but also extends to situations where the courts have yet to rule, but we believe a sex-based charter breach would be found. However, the government has been clear that in circumstances where the courts have ruled policies to be charter compliant, where situations are more complex than purely alleged sex-based inequities, government action must be based upon meeting consultations, as is stated in the UN Declaration on the Rights of Indigenous Peoples. Despite supporting numerous amendments proposed and adopted by the Senate Committee, the government has made it clear that it cannot support one amendment put forward by Senator McPhedran and accepted by the Senate. The intention of Senator McPhedran's amendment to Clause 1 of Bill S3 would seem to provide entitlement for Indian registration to all direct descendants born prior to April 17, 1985, of individuals previously entitled as Indians under previous Indian Acts, possibly back to 1876. In simpler terms, this clause seeks to implement the approach commonly referred to as 6-1A all the way. In simpler terms, this clause seeks to implement the approach commonly referred to as 618 all the way. Mais je crois que cet amendement a été proposé.
While I believe this amendment was put forward with the best of intentions, the way this clause is drafted creates ambiguity as to whether it would even do what it is intended to do.
Ambiguity was highlighted by Senator Sinclair during clause by clause at the committee and by the Indigenous Bar Association when they testified before this committee. And if this clause is interpreted in a way to implement the 618 all the way approach, then it could potentially extend status to a broad range of individuals impacted by a wide range of alleged inequities, well beyond those that are sex-based. The government is open to considering this approach through stage 2. But we have not adequately consulted with those who could be impacted, and we do not currently have the demographic information to understand the actual practical implications of implementing such an approach. While the government is initiating that work now, preliminary estimates are not based on reliable data and contain huge ranges of potentially newly entitled individuals from 80,000 to 2 million. Highlighting these numbers is not to suggest either end of the spectrum is what the impact would be, but to note that the huge range of current estimates and the need for better data. Non seulement y a-t-il un manque de...
In addition to the current lack of understanding of the practical implications of the approach, it is clear that the necessary consultation has not occurred.
We have the profound impacts on communities which could find themselves with huge numbers of new members with little or no connection to their community and without any meaningful prior consultation. I want to understand the perspectives and concerns of the vast number of potentially impacted people who have not yet even been asked their opinion on 618 all the way. But this particular clause was not part of any prior consultation. I want to be clear. I stand in solidarity with the Indigenous women who have been fighting on these issues for decades. I hear the pain, the hurt of receiving a letter in which they were told their marriage made them a white woman. Whether these remaining issues are charter issues or not, I want to be part of fixing these ongoing problems. But we must be careful not to repeat the mistakes of the past, where even sometimes with admirable intentions, policies are implemented absent proper consultation or evidence and result in dire, unintended consequences. I want to work with communities, impacted individuals, and experts to ensure that we finally get this right. The concerns expressed by many about the drafting of this specific clause show how easy it is to get this wrong if it is rushed. As many of you may be aware, there is a court deadline for this legislation of July 2nd. Si le projet de loi qui répond aux éléments...
If we do not have legislation passed which addresses the charter issues outlined in the Deceno decision before July 3rd, the sections struck down by the court will be inoperative in Quebec.
It would be that these provisions will then become inoperative within Canada. 90% of status Indians are registered by the federal government under the provisions that would be inoperable. In addition to up to the 35,000 individuals waiting for their rights to be granted through S3, we cannot lose sight of the thousands of individuals who will not be able to register if the court deadline passes and the provisions noted above become inoperable. In conclusion, I ask you to vote against the 618 all the way clause and send this bill back to the Senate in a form that respects our duty to consult and allows us the time through stage 2 to finally get this right.
Thank you. Our first questioning comes from MP Michael McLeod.
Thank you, Madam Chair, and thank you to the Minister and the delegation that's presenting to us today on this issue. it really puts me in an awkward situation here to be deciding on who should be an Aboriginal Indigenous person and wrestling with this issue, which should not be in place. You know, the process should have had prior consultation way back. We should have had. We shouldn't be dealing with the government resisting change. This shouldn't have been court-induced. However, we're here in this situation. And I'm from the Northwest Territories, and we have a lot going on in terms of dealing with some of the issues that have been impacting us on the Aboriginal Indigenous agenda. And we have 10 sets of discussions going on, negotiations on land claims, self-government, and we don't have reserves. We have public communities. So the impact for migration, in migration, certainly won't be something that concerns us as much. However, we are concerned about the impact on land claims and self-government. Land quantum, compensation is all based on numbers. So more people for us means more numbers, more ability to negotiate bigger agreements. However, having said that, we are still locked into dealing with numbers from 1970. So I'm not sure how this, you know, as we talk about impact, how does this impact? How do we talk to people that are in these discussions? Because they will determine their own membership, but they'll be starting from a base from the time they're signing. So I'm a little bit nervous of, do we wait to settle the land claims after this issue is dealt with? Should we move forward? Any opinion on that?
It's a great question, because I think that, you know, as I've said before at this committee, the citizenship of a nation should not be Canada's business. This is very clear in the UN Declaration that only nations can determine their citizenship. And so we feel that this process of getting out from under the Indian Act and being able to just fix these inequities that were enshrined in it is part of a larger process to self-determination and to putting my friend Nathalie out of work. This is what we want to do ultimately. And so that the, as you say, the population of a community needs to be up to them, and it shouldn't be being decided by courts or Canada or in this way. So we feel that this is a interim step, and then phase 2 will be another interim step. Okay. But in the meantime, we're trying to get on with those conversations towards self-government, so that communities can make their own
Thank you
decisions.
for that. And I'm very happy that we're no longer fighting this piece of legislation. We're moving forward. There's an amendment that is causing concern. We've heard concern from Senator Sinclair. We've heard it from the Indigenous Bar Association that the wording may cause complications, it's not wording properly. It may clash with other parts of the bill. But I heard something, and we also heard that nobody trusts Indigenous affairs. We heard that loud and clear. And the 18-month plan to consult will take us into probably the next government. And I might not be sitting here. We may have different people occupying these seats. I heard today from Catherine Twin that brought up an interesting concept that I didn't realize was an option, but to take, let me ask you, what is the possibility of having the impact consultations be led by both houses, dealing with Senate and this?
No, I mean, I think we're open to that. I mean, I think one of the best committees I ever sat on was a joint committee of the House of Commons and the Senate. I mean, I think that we want to make, in our commitment to co-design the process with Indigenous people, those impacted by it, by First Nations or whatever, then if they think that that would be a more more efficient way of doing this and not doing it twice, we're open to anything. But what we're codifying in the bill is that we will report back within 12 months as the progress we're making. We need to be efficient about the co-design within 6 months. We need to have a really good approach to meaningful engagement. Make sure we get the people who aren't generally sitting around these tables but would be impacted or have been impacted by this. How do we get all those voices into the engagement sessions? And then we would, remember there's the three things. We report back to you within 5 months on the design. We launch within 6 months, and we have to report back to Parliament within 6 months or 12 months of our progress to date. We hear you in terms of nobody trusts, the Indian agent. I guess I'm just saying that as somebody, as a feminist and as somebody who spent my whole career in the doctor-patient relationship, but also with elected representative and the community and engaged citizens, that I am serious about this being a meaningful engagement and being able to get real results that will allow us the practical way of implementing whatever the new changes would be. How do we make sure that achieving equality and equity is actually fair and that everybody will buy in to that process, that it is a legitimate and fair process as we go forward?
Thank you. Questioning now moves to Kathy McLeod.
Thank you, Madam Chair, and thank you, Minister, for joining us today to talk about a very important piece of legislation. I want to actually point out first, it has been a very bizarre process. Typically in House of Commons committees, we will study the bill after it's been referred to from the House. In this case, way back in November, we supported it to do our due diligence, recognizing your Supreme Court of Canada deadline, and looked into a pre-study while the committee was looking at it. And we're now doing another pre-study, and I understand sort of a rush to clause by clause, and there hasn't been 1 minute's worth of debate in the House. So I think I do want to flag that as certainly a very unusual circumstance in terms of my experience as a parliamentarian since 2008. Now, having said that, I have some significant concerns that relate to sort of what was said back in November and what we're hearing now. So if I want to go back to November 21st, I asked the department officials if they're confident that S3, as it stood on that day, would eliminate all known sex-based inequities. I was told on the record that they were confident. The official said, quote, "In terms of your specific question for sex-based discrimination, yes, this bill is addressing everything that is wrong." So that was what was told to us now. Then today we see the sort of amended version come back, and we have, of course, the Gell case, and we have some other changes that have been made, and you're talking about making changes based on what the Indigenous Bar Association told you about sex-based inequities. So Tuesday I said the definition of known is that when the courts have directed as opposed to known by looking at the issue broadly. And at that time, Mr. Reiher said, actually, as we indicated, it's what the courts have decided plus what is clear. So that, to me, way back in November, you knew about the court case it was proceeding through. You knew about these issues. And so when I asked, is this dealing with all sex-based inequities on Tuesday again, how can I have confidence in the answer that yes, it was, when clearly I was given the same answer in November, and we're dealing with 2 more cases, or we're dealing with changes because indeed, I mean, to me, it's inconceivable that you knew about one case going through the courts and it wasn't dealt with. So perhaps you could sort of explain to me how we can have confidence now when we were given the same information in November that was clearly wrong.
So I want to start, Kathy, by saying that the first thing we had to do was remove the judicial review that the Conservative government had placed on the Deschanel decision. So the first thing we had to do was lift that judicial review. Then we said we'd accept what was in the exact case of Deschanel. Then we said we could add some other things that we know. And then the Gale case was actually about unstated paternity. So we have added a number of things to what was the letter of the Deschanel case in order to go more broadly on these issues that we believe are charter issues. The BC Court of Appeal said that the McIver 61A all the way was not, we didn't have to reach back that far to be charter compliant. So what we are saying now is we are doing everything that we know is a charter issue and more, but now we've got to get out and consult on the things that actually are policy decisions as opposed to charter compliance.
Okay. So you were saying that the Gale case didn't meet your criteria because it wasn't sex-based discrimination, or the years were too early in your opinion?
I think what we said at the committee in the Senate was that unstated paternity was going, at that point, we believed it would be in phase 2. And I think that people like Senator Sinclair and others really hoped that we would be able to deal with unstated paternity in this. So, because of the Gale case, we were able to make that amendment and that change now, but we believe the rest is policy decisions that have to be consulted with First Nations, in nothing about us without us, because they are not charter issues.
So I guess when the statement was made, we're dealing with all sex-based known inequities, but this one can wait till phase 2. So it's a little bit of a concern there. But I want to head to the next area of my questioning.
Kathy, we didn't believe that was charter, but because the court had ruled, we decided we can do this in this phase, and that's a bonus.
I know 7 minutes just flies by, so I really want to get to my next. The 6-1A all the way, I was told on Tuesday that it could have very wide-ranging implications in terms of beyond going the sex, gender-based inequities. Now, I do know that the law clerk did add for clarity the A2, where for the purpose of this provision, it's entitled, it really sort of clarifies that it really is about the matrilineal descents and the issue of sex-based gender inequity. So I guess I would ask, why are you not confident that the drafting, when they actually have put more clarification than the Liberals did when they submitted the amendment, because it's the exact same amendment as the Liberals submitted for McIver, but the clerk has created more drafting and clarity around what it's doing. So am I to understand that that does not, in your opinion, create the clarity that's needed in terms of gender-based issues?
Very short response, 10 seconds.
No, I think as Michael McLeod said, that the ambiguity that's there, as Senator Sinclair has said, that it may well not do what it was intended to do, and may actually contradict other parts of the bill, that's why we need to consult, but we also need to consult on how we determine this fairly and put in place a process with integrity that will be supported.
Questioning moves to MP Saganash.
Thank you, Madam Chair, and thank you, Madam Minister, to come before us again, and welcome back to the others who were here on Tuesday. You said in your remarks that government action needs to be based on meaningful consultation with Indigenous peoples, and you referred to the UN Declaration on the Rights of Indigenous Peoples. What is unfortunate is that you and your government, in spite of your promises, do not apply that rule across the board. And I can refer to a lot of cases in this country. Let me just cite CDAM, for instance, as a case in point. Speaking of that 61A all the way, I'm profoundly shocked and totally disturbed by the suggestion that this is a choice between human rights and dollars. That's shocking. That's disturbing to hear. In this country we call Canada, in 2017, to suggest that we have a choice between human rights and dollars, that's unacceptable. And that was a suggestion also that I heard from the other side. So I don't think we should be talking on that basis.
I agree.
Not in this country.
I agree.
You supported these amendments in the past when you were in opposition. The present Justice Minister supported these amendments in the past as well when she was Vice Chief for British Columbia. So what happened since then? Which Carolyn Bennett do we have before us this morning?
As you know, I was not the critic at the time, and not being a lawyer, I think it was very. It was a decision of Todd Russell at the time that something that he would like to see. I think what I'm saying is that it is it needs now to be understood that reaching equality and fairness is not an issue of money. It is not an issue of money. This is an issue of fairness and putting in place a process for determining who has status or not, in a process with integrity that people understand and have bought into. Because the BC Court of Appeal decided this is not necessary for charter compliance, we have to get out there and consult to make sure this is done properly. And it needs to be with all of the voices, not just chiefs and council. It's got to be the women and the people who've been sorely affected by this for a very long time. So that's why we set up the phase 1, phase 2. We do need the numbers because there's going to be impacts on communities, and we've got to make sure the resources are there to be able to have communities outreach to their new members, to be able to look at the voting systems on education, on land claims, that all of those things are based on 25% voter turnout. These things could be seriously affected if we don't do this right and get the resources there to help communities engage with their new members. And that's why this consultation on phase 2 becomes so important.
You know what is surprising in this discussion is that you, as Minister of the Crown, has decided that we need to consult more on human rights. Can you tell me of any other group in this country that you call Canada in 2017 requires that they be consulted on their fundamental human rights? Do you know of any other group besides Indigenous peoples?
I think the issue, Romeo, for even the early conversations, there are other inequities in the Indian Act, like enfranchisement. There are a number of where we will have to get the data and we'll have to figure out how we implement this. That is what phase 2 is about. We want to get rid of all of the inequities in the Indian Act. These that are in S3 are the ones the court told us to do, and we did even more than what the court asked. Now we have to get on and get rid of the rest of them. And I am committed to doing that.
I appreciate your commitment, your personal commitment, and one of the things that the Human Rights Tribunal said recently, talking about your words, and your department. Your department does, you say one thing, and your department does exactly the opposite. Can you tell me who's running the show here?
Well, firstly, I disagree.
That's why nobody trusts INAC.
Yeah. Well, I think that I want to say that the officials at INAC have done nothing but that loyal implementation that great public servants want to be able to do. The fact that we have almost 30% Indigenous people in INAN who now can see their fingerprints on better policies and going forward, I'm very, very proud of my department. And I think that, again, it's a matter of the relationships that these amazing people have in community. They've lived it themselves, and that we have to be very, very careful in those kinds of generalizations, because I agree, the leadership starts at the top, but it starts with our Prime Minister. He couldn't have been clearer to every Minister of the Crown and every public service servant that this is the most important relationship, and we have a very big steamship to turn around, but we're doing it step by step, and I am proud of the progress we've made.
Can you quickly comment on on Clause 10 with respect to the no liability of the Crown? I'm firmly opposed to that provision because it invites us, it's a proposition to justify past human rights wrongs in 2017.
15 seconds.
Is that your understanding as well?
It's a common provision in most of what we do, but it also is intended to protect First Nations communities from their liability in decisions that they have taken. I understand it. Part of it is before the courts now, but this is what we need to protect First Nations communities.
Thank you. Questioning now moves to MP Bossio.
Thank you so much for being here today, Minister. I was saying earlier with an earlier panel that I wasn't aware of this even being an issue until 2014 when I was at a women's Native restorative justice symposium back in 2014, and Dr. Marlene Brand-Castellano was a friend of mine, and I didn't even know at that time that she was impacted by this until that day, and there were a number of people. Jeanette is here as well that testified earlier, and I'd met her that day and heard their stories about the fight to right a wrong and injustice. And to me, it's appalling that you know, as Romeo, I mean, I have to agree with Romeo in that in Canada, we know today that this still exists. It's incredible, and you know, I have to say that I'm struck by the passion and the frustration, you know, over the decades of governments coming back again and again and again and say, we're going to fix this, we're going to get out, we're going to consult, and we're going to deal with it once and for all and be done with it. And here they are again today, and they're saying, okay, you know what, you're going part way to fixing a problem that's existed for forever, and we're not fully fixing the problem to deal with it once and for all. And you know, yes, we're making commitments in phase 2 to say yes, we've got a process and we're going to follow this process. And we've got timelines that we're going to dedicate ourselves towards, but they still do not have the confidence that phase 2 is going to fix the problem, and that our government is going to, in this mandate, be able to once and for all put an end to sex-based discrimination towards Indigenous women. And girls and generations of siblings. How do you and you know, Carolyn Bennett, that I know in your soul that you believe in that is your desire to put an end to this once and for all. But as you said, we've got this massive steamship that we're trying to turn and trying to get moving in this direction. If we don't put an end once and for all in this, saying that sexual-based discrimination is ending today in this bill as it's amended, in that phase 2 is only to deal with the non-sex-based discrimination and how we implement this bill, right? How do you give them that confidence if we don't have that written in the bill right now as it stands?
Well, I think that, I mean, firstly, I want to thank you for this, because I think we do need to underline the women that have been fighting for this for a very long time. I think we've talked before about, you know, the real impacts of the Indian Act, but before that, that the settlers would come and only speak to the men. The disempowering of women's voices over the generations has ended up with missing and murdered Indigenous women and girls. There's no question that the loss of women, Indigenous women's voices in their communities and the way they were dealt with by government has had disastrous effects. And so I understand that, and I do believe that the commitment now to deal with the pre-1951 and the second generation cutoff and adoption and enfranchisement, people who went to university or joined the armed forces, that we will have to be very intentional about dealing with all of those discriminations and inequities in phase 2. And that is like unbelievably serious commitment by myself and our department. So it is about doing what we can do now, but also honoring my commitment of the duty to consult, to make sure that the process we put in place for the areas for which we have really no good records, who gets status, who doesn't get status, how do we engage and get the answers as to what would be a system that would make sure the people who get status actually are exercising rights that they rightfully hold. So that's the integrity of the system, I think, is what people want, because again, we are now delving into an area, and we talked about that when I was here before, about date of birth and all of those things, that is the things in the areas where there are no good records, where we've got to design a real process to get this done properly.
The other big issue, of course, and that we're trying to deal with here is, yes, we're trying to move beyond the Indian Act towards self-determination for all Indigenous communities. And on one hand, we want Indigenous communities to have the right to determine who's going to be a member, who's not going to be a member, who's going to be status and not status. But at the other side, we've got this discrimination that exists and has existed for hundreds of years. How do we square this circle between on the one side, we have self-determination and First Nations making that determination. On the other side, we've got the Charter of Rights and Freedoms and what is, as we know, blatant discrimination.
Well, I think it's even more complex than that, Mike. That in reconstituting nations, that at the moment there are the governance is in Indian Act chiefs and council, and there's lots of hereditary leadership that don't feel heard, that we actually, as we reconstitute nation to nation, that this is going to be complex, but really the way we have to go in actually doing what this feels like, what is meant by nation to nation and government to government. So this is going to be about really moving to self-determination and having Indigenous people in charge of their citizenship.
The 5-minute round begins with MP Yurdega.
Thank you, Madam Chair, and thank the Minister for coming before us today. It seems like we try to overcomplicate everything. So this is too complex. Gender equality is a gender equality. I mean, what's good for A is good for B. I mean, you just can't legislate who you are. It's your genetics. So I understand that the government's not going to be supporting the Senate amendments. Anyways, can these issues be addressed in phase 2? And can you describe who's running phase 2? Is it INAC, or is it going to be commission, or how it's going to be made up? Because that's very important.
Well, this is something that we really have been discussing. Some people have suggested there could be a ministerial special representative to run it. Other people think that would be a bad idea. So we are going to have to decide how we do this. It was interesting to hear the suggestion of the two houses, making sure that they knew, because we have committed that we will report on the design back to Parliament within 5 months. We're committed to launch stage 2 within 6 months. Progress report to Parliament, both houses, in 12 months, but also a 3-year review clause to determine, whether we have really gotten rid of all the sex-based inequities in terms of eliminating them. So it is my personal commitment that this engagement will be robust and inclusive of all the voices that need to be heard on this, of all the people who have been impacted by this or could be impacted by this in terms of their children and grandchildren and great-grandchildren. So this is again going to be the hard piece of work over the next 5 months, where we are, because the process is one thing, the design of the process is going to be imperative that people trust it and know that it's meaningful, in the same way as we spent time as ministers designing the process for missing and murdered Indigenous women and girls to make sure that it was trauma-informed and that the families would be at the center of it. The designing the process is sometimes as important work as the process itself.
Thank you. And I think this is more of a money issue than anything else, because we heard from the other side the resources available and what is it going to cost. I think that's really mandated. The government's pushed this down the road, 4, 5, 6 years, how long it ever takes. Did the government calculate the cost of eliminating all the sex-based discrimination? Is there numbers out there that startled the government, say, oh, gee, we can't do this because it's going to cost us X amount of dollars? Is there anything, was there calculations ever done? Because I think that's the first place to look.
Well, I'm afraid that you've walked into a question, which is the reason your government, or the Conservative government, did the judicial review in the first place, because there were very clear numbers that would be between 25 and 35,000 new status Indians. And so we have embraced that as we will do that and more. And that's kind of what Romeo Saganash was saying, is that it shouldn't be between rights and money. We don't see that. But we do think that in order to determine who has rights, that there actually has to be a process with integrity that determines who has those rights. So the cases in Deschanel and Gale are clear as to who has rights. The phase 2 is to determine how do we determine a process where we can get the right numbers and get the people who have those rights the status that they deserve.
Thank you. You have 30 seconds.
Okay, that's not a lot of time, but I just, when is phase 2 going to be rolling out? Obviously, we want to get S3 going to go through the House shortly. When does phase 2 start?
Within the legislation, it needs to be rolled out within 6 months, and that we have to report to Parliament at 5 months on the design that has been agreed upon, so that we can launch at that 6-month point from royal assent.
Thank you. Moving on, questioning goes to MP Ananda Sangri.
Thank you, Madam Chair, Madam Minister, and colleagues. Welcome, welcome once again. We heard a great deal of skepticism, Madam Minister, about the approach that Canadian governments have taken in the past with respect to expanding the definition and the fight for equality within the membership of the Indian Act. And I think the previous panel talked about Lovelace and McIver and Deschanel and all the phase 2s that ought to have happened but never really happened and never really followed through with future legislation. And I think there's a great deal of validity to those concerns, and I think history has proven that is accurate. What is different now? What is it that makes us different, other than the fact that you're the lead in the department, that will make sure that there will be a phase two, there'll be a meaningful phase two with meaningful outcomes, with proper legislation to follow?
The first thing is we pulled the appeal on the judicial review that the previous government had done, and we accepted the ruling of Deschanel. And I think, Gary, what is important to understand is Deschanel only came because of the gaps in what had been in the legislation to McIver. So a number of things were missed, and therefore Deschanel went to court to say you missed these things in the bill responding to McIver. So what we're trying to do now is say we've done this bit, but we're not done yet. We are going to design a process to make sure that all of it is done, and that you, Parliament, will hold us to it, that we're going to get this thing done properly with no unintended consequences, no gaps that were missed, that we will get this whole business of discrimination in the Indian Act dealt with.
So last time David Schultz testified on Tuesday, and he had indicated that there was a case conference with the possibility, discussion with the possibility of extending time. Given the time pressures that we're facing, and given the Senate amendments, would it be appropriate for us to seek an extension? And if so, are you able to update us on any developments on that front?
I think we've lived what truncated engagement looks like in terms of these pieces. So I believe strongly that we need this bill passed, and we need to get those 35,000 people plus their rights. Even in conversations, some of these people, their kids need to go to university this fall. They need to be statused by this fall when they apply to university. So drawing this out any longer for the people that clearly have court-awarded rights and all of those that we have added in this process, I think it would be a disservice, and we need to get on and do all of the rest of it in a timely fashion such that we can get everybody who deserves status their rights.
So on that point, do we have a process of fast-tracking, priority registration? If we were to pass this, is there a process that you have to fast-track for those who may require that, for example, to apply to university in the fall? Is that a process that maybe the registrar can answer that will be in place to ensure that there's a priority for those who may be seeking or who may be in need of that additional recognition?
Absolutely. We are now in Natalie as the registrar. They are in the process of hiring extra resources in order to deal with this group of people who will receive status because of S3. Natalie, did you want to say?
I would just add that the minister is correct. We are in the process of staffing up. There's been 19 million earmarked to support the application process for additional individuals in the register.
Good. The final session of questioning goes to Kathy McLeod.
Thank you, Madam Chair. And so to the minister, what I'm hearing, and I mean, we're living with the reality of a majority government, that you accept this bill with the exclusion of the 6.1 ALN. Is that accurate? So you're definitive on that particular?
Yes, we have accepted all the advice and all the other amendments from the Senate, and but the one that we find difficult in terms of practical implementation, we are unable to accept.
And I do sort of want to note, you did sort of reference Senator Murray Sinclair, but I believe when it came to the Senate, it was unanimous in the Senate, was it not, including...
No, Senator Sinclair voted against the amendment.
And thank you for that clarification. And so my next question, and I just want to ask this again, and it's my third time asking, are you confident that Bill S3, as you are proposing the committee accept it, will eliminate all known sex-based inequities in the Act?
Yes, I mean, we said known sex-based inequities, and we are taking guidance from the BC Court of Appeal that actually determined that the McIver recommendation was not necessary in order for the department to operate in a charter compliant way, but we want to deal with that in terms of second generation cutoff and pre-1951 and all of those issues in phase 2.
Okay. So my other, I'm going to head into your phase 2 process, and I've suggested this before. The concept nation to nation, which I'm not sure is clear in many people's mind as of yet, but clearly, as you're talking to communities, nations, bands on something as fundamental as registration and how this phase 2 process moves forward, do you not believe that you need to have that kind of definition, formal relationship established in order to do that important work? Because to me, it's sort of step 1, step 2, and I don't have any perception of how you could do step 1 in the time frame that you've created. And to me, that is, given what you've said as a government in terms of how you're going to move forward, it's a pretty logical sequencing.
So whether you're talking about the AFN or whether you're talking about self-governing
nation to nation,
the nation to nation piece is not as relevant in this case because there are a number of excluded individuals that will need to be consulted. So we will actually have to deal with all of the chiefs and council, the heads of the self-governing nations, and we've reached out to them. But the people that we're worried about are the people who have not really had an attachment to their community and because of history. So those are the voices that need to be in the consultation.
I can see that you need to have those additional voices, but I think that there is many communities who have not defined who their nation is for the purposes of these discussions, and you need that piece of work to be done.
And that is the work that is going to take us a few years, probably, but we're getting there. And we're very excited by the progress as these nations are reconstituting themselves in an education system or in a fishery or in all of the things that allow them to come together once again as a nation.
How can you do phase 2 without that work being done?
We're doing it.
20 seconds.
Thank you, Minister.
So the design is key. It's not going to be one size fits all, and there's going to be different kinds of engagement depending on the situations, coast to coast to coast.
Thank you. Thank you to the Minister, to the staff, for all of you participating in this historic hearing about S3. And I appreciate your attention, your cooperation, and our sincere thank you. Miigwech. For the committee members, I would just like to do an S3 reminder. A reminder that if members are wanting to prepare and submit amendments, to get in touch with Legislative Council as soon as possible. If the committee proceeds to clause by clause on S3 on Thursday the 15th, which is in our schedule, I would ask that members submit their final amendments to the clerk by Tuesday, June 13th. can also do it on the floor, but it's better if it's in a more formulated process so that the comprehensive packages as well can be prepared for our Thursday meeting. Kathy. Sorry.
Thank you, Madam Chair. I was just going to make that one question in terms of the amendments can come from the floor.
Yes.
So, thank you.
Thank you very much. That concludes our business.